Hello, everybody. Hope you're all having a wonderful night. I am here. You always say it out loud. I don't think you have a mute button. Hello, Rocky Lennon. All right, guys, we're going to get right into the case. I will be doing greetings as we go. But I don't know what I stumbled on tonight. I really don't, y'all. Yeah, come along with me on this magic carpet ride.
Your Honor, the last matter we have in custody is Mr. Phil Hart. That's on for arraignment. That's matter 24L000806, on for arraignment on a theft in the third degree.
Okay. Good morning, Mr. Phil Hart. Go ahead, counsel.
And Your Honor, for the record, Luis Carlo with Mr. Phil Hart directly to my right. We're here for arraignment. We acknowledge receipt of the complaint, waive any further formal reading, and ask the court to enter a plea of not guilty on Mr. Phil Hart's behalf. We do stipulate to probable cause for purposes of this hearing. Additionally, I have gone over Mr. Phil Hart's rights at arraignment. I believe he understands them in full. He is indigent and qualifies for the public defender. We ask that the court appoint Horwath Law. Thank you.
Thank you, and good morning again, Mr. Phil Hart. I have in front of me a document entitled Defendant's Rights at Arraignment. Have you had a chance to review these rights with your attorney?
Yes, I have.
Do you have any questions about those rights?
No, I don't, Your Honor.
All right. I am going to enter a plea of not guilty for you. I accept the stipulation of probable cause, and I will turn to the city for conditions of release.
In reviewing Mr. Phil Hart's 58 case criminal history, he currently has 6 active warrants. The city is not convinced that this track record is any indication that he will take this matter seriously or appear for court. I understand it's only a theft in the third degree, but with all of those outstanding warrants, the city is asking the court to impose a minimum of $5,000 bail.
What was the item alleged to have been stolen?
It is a T-shirt from Foxhole in Lakewood, and there was no value. It was a camouflage black and gray or black and blue T-shirt. There was no value in the police report.
Understood.
It was indicated in the police report that there were multiple thefts he was alleged to have occurred. I can pull that up and give the court that information if the court wants.
No, that's okay.
Okay.
What's the name of the location?
Foxhole, and it's 2 words, Foxhole.
Mr. Carlo.
Your Honor, while I understand that the court's concerned regarding any warrant history, this is a nonviolent crime, theft in the third degree. He stole a shirt. He's currently being held. No bail has been set on his Rob 1 in Superior Court. He has been held since the 13th. I ask that the court release him. If the court is not inclined to release him, I would ask for nominal bail. Thank you.
The address that I have on file is in Lakewood. Is that a good address?
Yeah.
I'm sorry, did you say yes, Your Honor?
Yes, Your Honor.
Great. So the important thing, sir, is if you ever get your address ever changed, you have to update it. Check your mail, don't ignore it. And if there's any other concerns, whether or not you're missing something, you always call the court, okay? The city makes a really excellent point that when somebody doesn't show up to court, it suggests they're not going to show up to court. And that if they continue to get trespassed or whatever, it's also not very useful. I did note that I forgot to indicate I am appointing Horwath Law, and I do that. At the same time, I do see criminal history that is consistent with your financial situation, and I'm required to take financial situation into account by the court rules. I am this time not going to impose bail. The city has every reason to request it. I'm going to release you on your promise to return your personal recognizance. I do not think it would be wise to pick up any additional charges. I don't know what Superior Court's going to do. They might release you, they might not. They release you and you change your address, you have to notify everyone. Do you understand?
Yes, Your Honor.
Okay. And do not violate the law while you're out. I think this morning you kind of may have understood that is not an acceptable practice in this courtroom. Do you understand? Good. I'm going to direct you to have no contact with Foxhole. Do not go there. Do not be within 1,000 feet of there. Do not ever put it on your radar again while this case is pending. Do you understand?
Yes.
We're going to set a pretrial date. He's not being held on this. Do we put an out of custody or an in custody date? Out custody date? 0. It's PR. He hasn't been yet. He hasn't gone before them. Okay. We're going to have you appear before us on June 18th at 1 p.m.
Your Honor, is that the in custody calendar?
No, it is not. He's released on PR.
Well, I guess the court should set both in the alternative because I'm not sure what Superior Court is going to do in terms of keeping him.
So
So he would have to be set to if he is held in Pierce County Jail, then he would have to be transported again and it would have to be done in the Pierce County Jail calendar.
right. So if he's held, I guess we can do that. Okay, yeah. We'll do that. The in custody date that we're going to set. Or am I in custody? It's not on here. Let's do 3 weeks. We'll select what time? June 5th at 10 a.m. Okay, where they put things all over the place for release on PR. It's never in the same spot. I found it, but it's never in the same spot. Can you review that order for me, please? All right, if the parties can sign the order, or if Mr. Carlo is. Okay, I believe that concludes your matter, Mr. Fillard. Thank you very much.
Thank you, Your Honor.
What's the next matter?
Mr. Salazar. Mr. Salazar refused to come to court now twice.
How are we handling that?
Well, the city would ask that the court order Mr. Salazar to appear. Let me just take a look. It's a theft third. Are there any mental health issues? Are there any mental health issues that you know of? The city made an offer to plead guilty and dismiss, and I don't know why. I haven't been at court, so I don't know. Do you know the reasons he's refusing? Okay. So I have no information other than to ask the court to make it mandatory and that he appear for court, and I can upload whatever document the clerk needs to make that happen.
Order on motion. If you'll upload an order on motion, and then Wendy's ahead of us.
She already put it in there. I was like, somebody did that already. All right, so that is uploaded.
Wendy knows this judge, I bet. She wants to be on the ball.
Let's see. And when do we want to set this?
When's the next time? We'll set it for Friday at 10 a.m.
All right.
and I'll let you put your motion language in as well.
What do you want me to list your position as? Position of non-moving party objects, joins, does not object. Oh, okay. All right, I'm gonna save this and let the court review. I'm not sure I got all of the correct information in there. I'll sign it and have the parties review it.
Definitely. By the principal and his observers.
If you can get.
Y'all, the star of the show has arrived.
If you can call him and get a plea and put
Let's
it
see if that's.
in. I mean, if it's,
Is the city moving to authorize the jail to utilize any sort of reasonable force.
Yes.
Happen?
Yes.
Okay. Is it okay if I add that into
Yes,
your
Your Honor.
motion? Okay. I'll edit and add it in and you just tell me if it's wrong. Okay, Ms. Schumacher?
I mean, if you can. Yeah, I mean, if you can get.
I've added the language, which I understand is your language, so you tell me if I'm wrong, Ms. Schumacher, that says jail personnel may use reasonable force to compel appearance. Is that accurate?
Yes, Your Honor. Thank you.
Are there conditions of release that have, no, this is for an arraignment?
Is this for an arraignment?
I'll just put conditions of release, if any, remain in effect. All right, Mr. Carlo, if you can sign, please.
Your Honor, typically we don't sign the drag orders, or just the order.
It's all right. No, if you don't typically sign it, then we will just proceed without your signature.
Thank you, Your Honor.
I am never going to compel you to sign an order to that effect, though I do make a note for the record that you are present and will receive a copy. And I do also see that there's no place to indicate, should you have signed, that you're approved as to form only, so I can understand your position.
Thank you, Your Honor. And I believe that concludes our Pierce County Jail calendar.
Thank you. And does that conclude your morning, Mr. Carlo?
It does, Your Honor. Ms. Mon will be handling Ms. Qualley.
All right, well then you have a great day.
You as well. Pleasure to see you.
So this judge so far, I mean, he seems so reasonable and so patient. Like he handled that so smoothly. He didn't mind making edits or anything. So far, he seems like such a great judge. I've not seen him personally before. But I like him.
You ready on Nisqually?
Good morning, Your Honor. This is Amin Man, for the record, defense attorney handling the Nisqually calendar today.
Ms. Amon, we cannot hear you.
Oh, Ms. Mon, we can't hear you. Ms. Schumacher, do you need to will you be logging into Zoom or no?
Yes, sorry.
Okay, that's okay. I just don't want to get started and go off to the races without you being ready. So you just let me know.
Can you hear me now?
See the all capital Nisqually jail? Is that on Jabs?
Yes, we can hear you.
Okay, you can hear me now?
Oh, I'm sorry, Ms. Mon. I didn't realize that was you. Well, Ms. Schumacher logs in. What's the name of this client?
If the individual in Nisqually can identify themselves, please.
Brendan Overzet.
Your Honor.
Thank you, Mr. Overzet. If you'll just wait just a moment while everyone gets logged in.
Yes, Your Honor.
And just so the court knows, I was not able to speak with Mr. Faust and Mr. Blades. So I will need a breakout room for a few individuals.
Okay, Ms. Mon, we will do that in the future when our calendar is running over here. You can still notify our court staff who's running the Zoom, and we can probably make that happen. So just so
Understood,
you're
Your Honor. I was on the phone with Nisqually. Nisqually is typically running short-staffed these days, so I have been on the phone with individuals speaking to them for the past hour and a half, but due to
Oh, I
issues-
see. Understood. Thank you.
Yeah.
Okay, are we ready, Ms. Schumacher?
I believe so. Can you still hear me? I connected without audio because I didn't want to have any feedback.
Yes, I can hear you.
Okay.
All right. Wonderful. So we'll begin with Mr. Overett, but thank you, sir. But I don't see an order or any, do I need to refresh? I don't see rights uploaded.
From my record, for Mr. Overzet, both of his cases are being dismissed today.
Okay, I will pause and wait. Go ahead, counsel.
Well, actually, this is news to me, so give me 1 second. Is this something you worked out with another attorney?
With Heidi, Amelia worked this out yesterday along with a few other cases.
And you didn't upload any of the orders that you worked out with Ms. Horst?
I didn't work that
Okay.
out. Attorney
Okay.
conducted and Ms. Watcher with the city did.
All right, so,
Here's what I'm gonna do. I'm gonna take a 10-minute recess. I would like the orders to be uploaded and I would like, the breakout rooms to be held for, well, we'll have to wait for Blades and, Faust to be brought down before you can use the breakout rooms. Is that correct?
she can call them on the phone if we're on a recess.
Ah, wonderful. So then we'll take a 10-minute recess and you can call them. And we can also get the orders uploaded. So
Thank you.
I'll return at 11:40 and we can go that way.
Thank you.
Thank you, Your Honor.
Now, keep in mind, I cut out all of the spaces of time where they weren't talking or where there was a very awkward silence while they had to amend orders or prepare orders or things like that. So there was a lot of space. This judge has given them a lot of grace for not having things together.
Amon, can you send me an email for what needs to be uploaded and I can upload it while you talk to the other two defendants?
Yeah, sounds good. I also sent you an email on Mr. Blades, if you can review that.
Sure.
Thank you.
All right. We are back in session. Let's proceed with Mr. Ozerts. Or, I'm sorry, Mr. Overset. Ms. Mon? All right. Ms. Squally, what would be the first matter? Hello, Mr. Overset.
Hello, Your Honor.
I still do not have an order for Mr. Overset. Oh, no, that's elsewhere. Let me refresh. No, still no order for Mr. Overset. What's going on, counsel?
Mr. Overset, the city is willing, and I'm loading, I apologize. The city is willing to dismiss the domestic violence charge 696, and I'll load that order. Apparently, the victim is not on board and the city is unable to proceed at this time. I will load that order of dismissal for those counts. The cause number entering in 640, I reviewed that. It appears to be a non-domestic violence, separate victim, separate incident, and there's no indication that the city is unable to proceed. So if that's not going to be a plea today, we would set that for trial.
Ms. Mon.
Your Honor, the resolution that I had before me that both of these cases would be dismissed today. So I am not ready to enter into a plea, but I do have another attorney that can work and recontact Mr. Overset while we continue with the other matters to discuss whether he wants to take the offer.
Oh, no. I'll accept the dismissal of, this calendar was supposed to start 54 minutes ago, and this is the first matter on the docket. We are not going to keep delaying. So we will set this for trial. If you all want to resolve it before the day of trial. And I will sign the order of dismissal for the cause number ending in 696.
Understood, Your Honor. I'd ask that this gets set to the May trial term.
What is speedy trial, Ms. Bond?
One moment, I can get that for you.
I have filled out an order on the cause number ending in 696 for malicious mischief, 2 counts, exposing minor to DV, 4 counts, asking the court to dismiss without prejudice. At this time, the city is unable to proceed.
I will sign the order.
And no objection to signing the non-DV 640 matter for trial in May. I can look also for speedy on that.
Speedy expires 6/22.
Okay. So when does that get set for trial? Thank you. This Wednesday? Next Wednesday? Okay. Ms. Schumacher, if you'll get out of that dismissal, I'll sign it.
Yes, Your Honor.
And is he being held on the 640?
Let me check. No, he is not being held on that matter.
So we'll need an order to have him released.
So I'll upload a conditions of release on the 640 matter. Or I see there's already a pretrial conference. Is that the order the court is looking for?
Is
Or
that,
it's called a release order, right?
so is that the order we need to use? Okay. We'll use the pretrial order.
Okay. Thank you. If the clerk uploaded that, I appreciate it.
She seems very on the ball and very well put together. She knows where all the documents are. She knows exactly what steps she needs to take. She is a very good prosecutor.
I believe it's Wendy. Thank you, Wendy. I'm looking at this transport order. It needs to be effective on the 23rd. Is that correct, Wendy? At 9 a.m.? Oh, we don't need it. He's going to be released. Ms. Mon, is Mr. Overzet being held on any other matters?
Your Honor, from my review of Jabs, he is not held on anything else.
Okay.
Yep, he has no warrants or anything like that, or holds out of any other district or city.
Understood. Thank you. Will the readiness hearing be tomorrow?
I think today is the readiness hearing, Your Honor. And so I've indicated on the pretrial form, discovery is complete. I don't believe that there are any motions. I did indicate the city would reserve, but I don't even think we have time to reserve motions given trial is Wednesday. I think what the city's plan will be is if our victim shows up, we'll proceed. If our victim doesn't show up, we'll dismiss on the day of trial. But I don't have any other information for the court today.
I'm familiar with that situation, Ms. Schumacher. Understood. Ms. Mon, are there any affirmative defenses?
Your Honor, none at this time.
Okay, Mr. Overzet, your matter ending in 696 has been dismissed. I heard the reasoning provided. I cannot help but notice there's significant other crimes that have been dismissed from 2016. And while I am not able to, there's an echo. While I'm not able to, whose echo is that? Can someone please address that? You'll mute, Ms. Schumacher. No, not that, but if you'll mute yours, Zoom.
I will. I didn't join with the audio, so it shouldn't be on, but I will find that and see if that's me. I can't mute because I never joined audio.
Understood. So it's not Ms. Schumacher. At any rate, sir, I'm noticing that your history, Ms. Mon, I'm ruling. I'm noticing that your history is somewhat concerning. And though I can't make a ruling on it, and I can't order you to do any treatment or any of your self-work, you're going to just be back here again if you don't.
Yes,
Okay.
Your Honor.
So these allegations that brought you before me, do everything you can to not have allegations. And I don't mean by convincing people to put up with your bad behavior. What I mean is, what I mean is you take yourself to the proper professionals and get the treatment that will help you. Do you understand?
Yes, Your Honor. I've actually already got it set up to go to treatment.
Okay,
For
good. It's not an order of this court, but I don't want to see you back here.
Yes, Your Honor.
Except on this other case. So on this other case, you're going to appear before us on May 22nd at 8:30 a.m.
In person.
This coming Wednesday.
Yes, if in person.
Yes, in person.
Yes, Your
I need you here at 8:30 a.m. And we will see you at that time. Do you have any questions?
Yes, that's at the court office building next to the DA's HS in Lakewood, right?
Yes.
Okay. Thank you, Your Honor.
Thank you. Thank you, Nisqually. We can move to the next matter. What's your name, sir?
Charles Watson.
Thank you, Mr. Watson. Go ahead, counsel.
Your Honor, this is Mr. Watson. We've got two cases before us today, both in trial status. Cause number is 24L000540, cause number 24L000737. Your Honor, we have worked out a negotiation with the city to have Mr. Watson sign a non-driving declaration today, and we will also be I've uploaded a motion to continue on his cases. There's some further investigation that needs to be completed in his matter. And the basis for signing that non-driving declaration is so that Mr. Watson can proceed with his matters out of custody.
Ms. Schumacher.
I need to have defense verify speedy trial. I'm also looking for Mr. Watson. I have no objection to the motion to continue. But I just want to make sure we have that extra. I know we're going to get 30 more days of speedy trial, but I want to just confirm. Looks like speedy trial expires on 6/28. And the motion to continue is to June 18th. So we would need a further extension of speedy trial for the city to agree. So I'd ask if the defense is comfortable with a new commencement date of today.
I believe I've had the date that I put for the pretrial would be June 18th. Can we revisit speedy then?
No, I'm not going to agree to set it to June 18th with speedy trial running on June 28th.
That's because he's in custody. If 30 additional days are given, then speedy doesn't expire.
Then I'd ask that you put that on the order that speedy trial expires 30 days from the 28th, so July 28th.
Okay, understood.
I'm not seeing any of these orders uploaded on my end. Have they been?
The one that we're talking about has been uploaded, the Watson one. I have not gone through each
There we go.
defendant just to look, but I've been emailing back and forth and several of them have resolved. So I believe we should be getting orders uploading as we're moving along.
Thank you.
And Ms. Schumacher, it shows me that you're still editing. If you want to add that in there, I'm okay with that, or I can add that as soon as you're out.
Yeah, it won't.
Okay, it shows that you're out. So I'll add.
Yeah, I can't figure it out. It says won't actually let me close even though it says I'm closed.
And I was not able to find a non-driving declaration in the documents prior to court. Do you know where that is?
I can look. You can also just put it in the continuance order.
Ms. Mon, did you not know that you'd be asking your client to sign a non-driving declaration before today?
I did, Your Honor, but I could not find it in the court documents.
I want to make something really clear. If an attorney is coming to court with a plan to engage in a resolution or a continuance or any action which requires a particular document, I would expect the attorney to arrive having prepared the documents or to know where they're at. My understanding is a non-driving declaration is under the DUI tab. So I am going to take a 5-minute break. I took this calendar started at 11:54. And I'm sitting here at 12:10 and I have meetings at 1 o'clock. We are stopping this calendar at 1 o'clock. Anything that is not done will be set over till tomorrow morning. And I do not want to come back and hear things like, I don't know where the documents are that I needed and knew about before the hearing started. So we are in recess and we will return at 12:15.
Thank you.
Oh, this was just the beginning. I hate to say it. It's going to get much worse before this ends. This is just the beginning.
Okay. Do we have all of our forms and documents uploaded and ready
Yes, Your Honor.
on the whole calendar?
Yes, Your Honor, at least that's from my end, yes.
Okay, great. So returning to the Watson matter, we have a motion to continue that has been uploaded that I'm going to review at this time. Is there an agreement that speedy trial ends on July 28th, 2024?
Yes, Your Honor.
Ms. Mon?
Yes, Your Honor.
Thank you. Is the intention for this person to be released on personal recognizance? Is that the request of the parties?
Yes, Your Honor.
Yes, Your Honor.
Is Mr. Watson unable to sign the declaration?
Your Honor, yes, he won't be able to sign,
Okay.
but we can mark served on defendant.
Hello, Mr. Watson. I have in front of me a declaration to not operate any motor vehicle without an ignition interlock device. Have you reviewed this document with your attorney, Ms. Mon?
Yes, Your Honor.
All right, do you agree to this condition in order to secure an agreement from the prosecutor to reduce your bail to personal recognizance and allow you to leave custody?
Yes, Your Honor.
You understand that this means you cannot operate any vehicle, whether or not you own the vehicle, without an ignition interlock device?
Yes, Your Honor.
Do you have any questions about those conditions for your attorney?
No, Your Honor.
All right, I'll accept your acknowledgement and indicate that you are serving this, that it is going to be served upon you. Okay. We're also going to order that we're also going to make that a condition of your sentence, or excuse me, not your sentence, of your release. I am going to grant the motion to continue your matter until June 18th, 2024 at 2 p.m. You're required to appear in person. Do you understand?
Yes, Your Honor.
We are going to release you on your promise to return your personal recognizance. You're not to drive a car without ignition interlock device, and all other conditions of release remain in effect. Do you have any questions about any of your conditions release at this time?
No, Your Honor.
Wonderful. Can't seem to get into the order. I'm gonna reload. Oh my gosh. Courts is now not letting me do anything.
Mine is really slow.
Okay, I have signed the orders. I believe that concludes your matter. What's the next matter, please?
So not only is he struggling with a very ill-prepared attorney, he also is struggling because the computer system isn't letting him do anything.
And thank you, sir. Have a good day.
Thank you.
Oh, that's right. I didn't sign yet. Thank you. What's your name, sir?
Eric Blades.
All right, Mr. Blades. Go ahead, counsel.
Your Honor, we have a few matters before the court today for Mr. Blades. We've got 2 review matters and I believe 1 pretrial matter. Today, we're asking for a motion to continue till Monday, Your Honor, as we need some further investigation and negotiation to occur before we resolve this matter.
Any objection from the city?
No, Your Honor.
Right. I will grant the motion to continue. Hold, sir, I'm going to continue your matter to. Who uploaded the order?
Your Honor, I did.
It doesn't appear that any of the order has been filled out. I will fill out the order.
I filled out the speedy trial waiver portion, Your Honor, indicating that it would restart today. I was waiting on defense to fill out the request. I didn't know what date they were asking to set this to. I apologize to the court.
No apology necessary. I was actually referring to the fact that the dates had not been input.
Right.
What time is the Monday hearing?
It happens at 1 p.m., Your Honor.
Okay.
And I,
Is this the defense or prosecutor's motion?
Your Honor, this is a defense motion.
Thank you. Mr. Blades, I have before me a motion to continue your matter to Monday with a speedy trial waiver beginning today, meaning that if you remain in custody, you'll have to be brought to trial by July 14th. And if not, then by August 13th. Do you understand that that is the request that your attorney is making on your behalf today?
Yes.
Have you had a chance to review the motion and ask your attorney any questions that she may have?
Yes.
Do you have any questions for your attorney at this time?
No.
Okay, then I will grant the motion and I will sign now. I have signed the order. Thank you, Mr. Blades. We'll see you on Monday. That concludes your matter for today. What's the next matter before us? Hello, sir. What's your name?
Juan Jimenez.
Thank you, Mr. Juan Jimenez.
Yeah.
Are you also known as Juan Jimenez Morales?
Yes, sir.
All right. Thank you so much. Good morning or
Good morning.
good afternoon. This is cause number 24L000760, a matter here today for, also a 4A00567666. These matters are here for a first pretrial conference. Ms. Schumacher, what are we doing with these matters?
I believe there's a plea that is been uploaded for Mr. Jimenez. It looks like
Right.
he is pleading guilty to the assault in the 4th degree. Oops.
With a dismissal of assault for exposing minor to domestic violence.
This was very confusing to me because on the docket, under these cause numbers, there's only one charge of assault 4th degree domestic violence on the cause number ending in 760. And then there's one count of driving while license suspended in the 4A number. So I'm not sure where all of these other counts are coming from. I didn't fill out the plea, so I don't know
I
if.
did fill out the plea, but that's just how it populated for me when I clicked on the cause numbers. So maybe it's an Oakworth's error. But I was under the same understanding that it was only pleading guilty to one assault in the 4th degree and dismissing the rest of the charges.
Right, dismissing one count of driving while license suspended under the 6766.
Well, as completed, this is an unconstitutional document, so I'm not going to be signing this plea today. We will be continuing this matter to the next available date. What is the next pretrial in custody?
That'll be this Friday. Your
Friday?
Honor.
Okay, then what we will, I'm sorry, what?
I just said that'll be this Friday, Your Honor. I was just answering your question.
Understood. Thank you. Sir, unfortunately, the plea that's been put before me is not constitutional and I'm not going to accept it. It doesn't mean you can't accept it at another time. We're just not going to hear it today. I'm going to set your matter over till this Friday at what time? 11 a.m. I have a motion to continue that's been uploaded.
I'm working on editing it, Your Honor.
Thank you.
And we're setting it to Friday at
But then you'd have to do the whole thing.
11. Okay, May 17th at 11. All right, I've saved that. I've indicated setting it over to May 17th at 11 o'clock. Both matters indicate that defendants is required in person or virtual. Form not filled out for court. It doesn't give me the option to do a continuance by the court. It only allows me to do defense, prosecutor, or defendant. So I've left that blank. And I've left the order part blank for the court to fill out, and I'll go ahead and save that and sign that.
Thank you. What would the effect of the plea have been if the court had followed the recommendation of the parties?
Credit for time served and release on the domestic violence assault form, an evaluation or DVMRT and a victim impact panel, and then dismiss the driving charge.
So he was to get out today, not the 17th.
That's correct.
So he would have been released
Correct.
if followed.
Correct.
She just cost her defendant his freedom, potentially, for a few days.
And I think just to shed
Yeah, go ahead.
I do think, because I know when I load up a form like a guilty plea, I think it populates with the charges. I don't think that defense had any control over the fact that the charges were incorrect. I don't know how they got in there because I don't think it's something we put in that form.
No, and that's not what we put in. It auto-populates for us.
Thank you, Ms. Schumacher. I appreciate that grace. I would also note that I'm familiar with doing plea agreements for over a decade, and plea agreements are typically prepared before people show up in court. So there's no reason we can just blame courts. So I expect next time documents will be prepared for court, before court. Sir, what we're going to do is we're going to set your matter aside. We're going to move on to the next matters. We're going to do everything we can to get you resolved today, because it sounds like that way we can make sure that if I do follow the recommendation, which I'm not saying I will, but you won't be punished for something that is not your fault. So I want you to, Nisqually, if we can set this matter aside and hold it, I expect that as I'm doing the other matters, the attorneys will be multitasking and also making sure that this order is complete so that when we do return to Mr. Jimenez, we can handle his plea. So Nisqually, if you can take Mr. Jimenez back and bring out the next person, please, but make sure Mr. Jimenez is on hand to come back to us. Sir, what's your name, please?
My name is Fernando Cortez Faust.
Oh, Mr. Faust, this matter is here on cause numbers 24L000226, a trial status, and 24L000502, another trial status, and cause number 24L000662, another trial status. What is the party's intention today?
Your Honor, there is a plea of guilty loaded in Oak Courts. The city is dismissing charge ending in 226, criminal trespass in the second degree, and charge ending in 662, theft in the third degree, both dismissals based on the court's acceptance of a plea of guilty to the charge 24L0502.
He seems positively giddy.
Thank you very much. Sir, I have in front of me a statement of defendant on plea of guilty. Have you had a chance to review this document with your attorney, Ms. Mon?
Yes.
And do you have any questions about this document before we begin?
No questions at all.
All right. I'm going to review this document with you, and then I'm going to ask Ms. Mon if she has anything to add before I take your plea on this matter. This document indicates that you will be pleading guilty to one count of assault in the fourth degree with sexual motivation, and that the crimes of criminal trespass in the second degree and theft in the third degree will be dismissed. Is that your understanding of the plea today?
Yes, I understand. I understand, Your Honor.
Okay. This document indicates that the charges for the crime to which you will be pleading guilty are contained in the charging document that was presented to you. Is that correct?
Yes.
Paragraph 5 indicates the important rights you give up anytime you plead guilty. They include the right to remain silent, the presumption of innocence, the right to appeal your conviction, the right to call witnesses without any expense to you, and other important rights. Have you reviewed these rights with your attorney, Ms. Mon?
Yes.
Do you waive these rights in order to allow us to proceed today?
Yes.
Do you have any questions for Ms. Mon about those rights in particular?
Yeah, no questions at all.
No questions at all.
Yeah, no questions.
Paragraph 6 contains the agreed
Got it.
recommendation of the parties. The parties are going to recommend 364 days with 338 suspended, that you be given credit for time served in the amount of 26 days, that the matter is to close thereafter, and that you not receive any fines. Is that your understanding of the recommendation today?
Yes, that means I'm released today, right?
If I follow the recommendation, that is
Okay.
correct. You
All right.
understand I do not have to follow the recommendation. The recommendation, I could sentence you up to 364 days and order a $5,000 fine, as well as any treatment that I think is appropriate. Do you understand that?
Yes, I understand, Your Honor.
I'm not asking today whether or not you're a citizen of the United States.
Yes, I am.
I'm not asking that.
Oh, okay, sorry.
Why has his counsel, why was paragraph 6G not initialed?
Your Honor, you said paragraph 16?
6G, I'm not a citizen of the United States. If I'm not a citizen of the United States, a plea of guilty to an offense punishable as a crime under state law may be grounds for deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Defendant's initials, it's left blank. Why?
Your Honor, because I don't usually sign that portion or any portion of a document that is a guilty plea on behalf of my clients. They don't have the means to sign anything while they're in custody. But I can, on this record, make the record that I am signing that portion on his behalf.
Right. I've seen the initials typed several times before, counsel. Is that not something you're able to do?
Your Honor, I can type them in now. It's just not something that I've done before, but I can type them in now.
So, sir, you understand that if you are not a citizen of the United States, a plea of guilty to an offense punishable as a crime under state law may be grounds for deportation, exclusion from admission to the US, or denial of naturalization pursuant to the laws of the United States. Do you understand that?
Yes, I understand, Your Honor.
Do you authorize your attorney, Ms. Mon, to indicate your initials FF by that portion of the plea agreement?
Yes, I understand.
Is there a registration requirement for this crime?
Your Honor, there is. And I believe I did mark the box for it. Just remarked it under W.
Sir, you
Sorry, no.
understand that this crime comes with a, I see it is now marked. Is that correct?
And yes, Your Honor.
Sir, are you aware that if you plead guilty to assault in the 4th degree with sexual motivation, you are required to register as a sex offender in the state of Washington, which means that you have to report your whereabouts to the sheriff's department in the county in which you reside, and that those requirements may be, you may have to report multiple times or more frequently if you do not have a fixed residence. Do you understand that is a requirement if you plead guilty to this crime?
Yes, I understand.
In your plea agreement, there was a box when you signed it that was not checked, but is now checked. It indicates that pursuant to RCW 43.43.754, that if you plead guilty to this crime, you are required to have a biological sample collected for purposes of DNA identification analysis, unless it's established that the Washington State Patrol Crime Laboratory already has a sample for a qualifying offense. Do you understand that's a requirement in this case if you plead guilty today?
Yes, I understand.
And just so Your Honor knows, I did review that with him when I was discussing his case.
So this does have a registration requirement?
Your Honor, he's pleading guilty to assault in the 4th degree with sexual motivation.
Thank you for that. My question to you is, does it have a registration requirement?
Per the RCW
Great. Which RCW?
43.43.754.
43.43.754 is a biological collection statute. It says nothing about registration. Is this a conviction that requires registration as a sex offender?
No, Your Honor. It requires, as you have stated, a biological sample collection.
When I asked earlier if this requires sex offender registration and was told yes, I then proceeded in my colloquy to advise your client or to ask your client if he knew the consequences. The reason I do that in a colloquy is I have to establish that this plea is made knowingly, intelligently, and voluntarily. To prove knowing, intelligent, and voluntariness, we have to prove under the Washington State Constitution and established case law that the person has been accurately advised about the law regarding pleas. If we fail to do that, we violate Mr. Faust's constitutional rights. I do not violate people's constitutional rights. When I ask if a statute applies, I'm not just asking as part of some academic exercise. I'm asking because it's important that your client does not have his rights violated by this court. If you do not understand my questions, Ms. Mon, I need you to ask to clarify them, okay?
Understood, Your Honor.
But I cannot have people in this courtroom while I'm attempting to protect the rights of a criminal defendant who is in custody, guessing at the statutes that apply. Are we clear?
Yes, Your Honor.
Okay, sir. We're going to do this all over again because the information I got is inaccurate. So we're going to go back through.
All right, no problem.
I appreciate your grace.
You're
You're being
welcome.
very patient, Mr. Faust.
You're welcome. Thank you.
I have in front of me, Mr. Faust, a statement of defendant on plea of guilty. This statement of defendant on plea of guilty was reviewed by you with your attorney. Is that correct?
Yes.
Did she read it to you? Did you read it yourself, or was it a combination of both?
It was a combination of both, Your Honor.
Great. When you read it, there were two portions that were not filled out. One of those portions is paragraph 6G, as in gamma, which talks about the United States and what a plea of guilty will do to citizenship status. Since you reviewed this with your attorney, your initials FF have been added to that line, to the line on 6G. Do you understand that?
Yes.
Does that change your desire to proceed with this plea?
No, Your Honor.
Great. Also, a checkbox next to paragraph 6X has been marked, which begins pursuant to RCW 43.43.754. Now that that has been checked, since you first reviewed this with your attorney, do you still want to proceed with this plea?
Yes, Your Honor.
Right. With those two changes to what you reviewed, I'm going to go through the plea. It indicates that you will be pleading guilty to assault in the 4th degree sexual motivation, and that the state will, or the city will dismiss criminal trespass 2nd degree and theft in the 3rd degree. Is that your understanding?
Yes, Your Honor.
Also, it indicates the charging elements are set out in the charging document. Is that accurate?
Yes, Your Honor.
Paragraph 5 contains the very important rights you give up anytime you plead guilty. They include the right to remain silent, the right to be presumed innocent, the right to appeal, and the right to call witnesses at no expense to you, as well as other rights. Do you understand the rights that you're waiving in order to plead guilty today?
Yes, Your Honor, I understand.
Do you want to proceed having waived those rights?
Yes, Your Honor.
The joint recommendation of the parties as contained in this document is that you serve 364 days with 338 suspended. You pay $0 in fine. You receive credit for time served of 26 days in custody, and the case will close. Is that your understanding of the recommendation?
Yes, Your Honor. That means sorry for talking over you.
You're okay.
Which means I will be released today, right?
That is the recommendation of the parties, correct.
Okay, thank you.
You understand I don't have to follow the recommendation of the parties. I could keep you in custody for 364 days if I wanted to in this case. Do you understand that?
Yes, I understand, Your Honor.
You understand the crime of assault in the 4th degree sexual motivation has a maximum sentence of 364 days and a $5,000 fine?
Yes, Your Honor, I understand.
You understand that if you're not a citizen of the United States, a plea of guilty to an offense punishable as a crime under state law may be grounds for deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States?
Yes, I understand, Your Honor.
You understand that a biological sample, meaning a DNA sample, will have to be taken from you after you plead guilty, unless it's been established that the crime lab already has a sample sample from you for a qualifying offense. Do you understand that?
Yes, I understand, Your Honor.
Has anyone made any threats or promises other than those contained in this now amended guilty plea in order to get you to enter the plea today?
No, Your Honor.
Do you make the plea freely and voluntarily?
Yes, Your Honor.
Paragraph 11 reads, on or about April 18th, 2024, in the city of Lakewood, I touched Ms. Alexis Petro in an offensive and inappropriate manner with sexual motivation. Are those the facts that make you guilty of this crime?
Yes, Your Honor.
Do you have any questions for your attorney before I ask how you plead in this matter?
No, Your Honor.
How do you plead?
May you say it again?
Certainly, and thank you for asking.
Oh, you're welcome.
Yeah. Do you have any questions for your attorney before I ask how you plead to this crime?
No questions.
How do you plead to the crime of assault in the 4th degree sexual motivation?
Guilty.
I accept your plea of guilty. I find that is knowingly, intelligently, and voluntarily made, and I do find you guilty of the crime of assault in the 4th degree with sexual motivation, and I do dismiss the crime of theft in the 3rd degree. I have the joint statement of the parties before me. Is there anything you would like me to know, Ms. Schumacher, apart from what's in the agreement?
No, it is an agreed upon recommendation. Thank you.
Thank you. Ms. Mon, anything to add?
Nothing further to add, Your Honor.
Thank you. Mr. Faust, you have what's called the right of allocution. You can say whatever you want, or you don't have to say anything before I pass sentence in this matter. What, if anything, would you like me to know before I pass sentence?
I'm so sorry for what I've done, and I realized the time that I was in jail, I realized what I've done, and I'm not ever going to do it again.
Thank you very much for your allocution, sir.
You're welcome.
I appreciate that.
I appreciate it so much for releasing me today, too.
Well, I haven't said,
Okay.
I
I'm
haven't-
sorry. I'm sorry. I'm just
Okay.
getting ahead of myself.
I haven't ruled yet, but I am going to follow the recommendation of the parties. I am going to order you to serve 338 days with 26 days credit for time served. And I'm going to close the file at this time. A DNA sample will be collected as is required. Wendy, can you review, please? Ms. Mon, please review and sign if accurate. No. Was one issued in this case?
And that's been signed, Your Honor.
All right. I have signed the order. And that concludes your case, Mr. Faust. Have a great day.
And does that mean I'm released today, or?
You will be, yes.
Yes, thank you so much. Yes.
Have a great day.
Thank you for being my judge. Thank you for being my, yes. You guys have a great day. Thank you, ma'am. Thank you,
You have
ma'am.
a good day, Mr. Faust.
Thank you.
Okay,
So the whole registering as an offender thing was not required for what he did. Basically it's equivalent to something like he smacked someone on the bum. That's kind of what that charge is. He didn't actually fully commit to an act like that, but he did inappropriately touch someone. So, but that charge does not require him to register in the database. And she had it marked on his file and had advised him and had advised the court that part of that statute was that he would have to register. No. The judge pulled it up and looked at it and read it right to her. The only thing he has to do is give a DNA sample. So that if he does something silly down the road that would require identifying him via DNA, they'd be able to. So now she's possibly cost a defendant his freedom for a few days. She nearly had someone who would not had the wherewithal of ever knowing that that was not actually a requirement of his charges, do you think he ever would have questioned it? He never would have gone back and looked in the law books or found the statute and realized, hey, I got extra stuff on here. No, he would have just accepted it and rolled on with his life. Because hypothetically, let's say he was the type of person to escalate in his crime and it became a point where he went full on. And they did a collection and tested it, he'd be in that database. Kind of like a fingerprint database, but for DNA. If he ever did something that required identifying him by that method, they have it. Yeah. That's the truth. That is so true, Rocky Lennon. Yes, everybody, I am on Instagram and we have cute videos of Ava on there, and we have the newest member of the paw firm, Baby Quirrell. She specializes in family law because her cuteness can settle any quarrel. So yeah. Oh yeah, she is thoroughly doing that. And just wait. Oh, you thought that was the end of that? Oh, no. It's gonna even get worse than this.
Squally, thank you. Sir, what's your name, please?
Christian Miguel RP Toa.
Thank you, Mr. Twide. This matter is here before the court on cause number 24L000677. It's a trial status hearing. Ms. Schumacher, what are we doing today?
Oh, I apologize, Your Honor. I'm sorry.
It's all right?
Let me take a look. I thought the defense was gonna call the next matter.
I apologize.
Nope, that's okay. I should have been paying more attention. Let me go back.
I see that there's been a guilty plea uploaded. Is that accurate?
Yes, Your Honor, that's accurate. This is a negotiated and agreed resolution in this case. This is a DUI amended down to a negligent driving in the first degree.
Okay.
The terms are credit for time served.
Thank you. I will review it with Mr. Twide. Mr. Twide, I have in front of me a document entitled Defendant's Statement of Defendant on Plea of Guilty. Did you review this document with your attorney, Ms. Mon?
Yes, Your Honor.
Did you read it? Did she read it to you, or was it a combination of both?
I was ready.
What's that?
They read it to me.
I'm sorry, I don't hear very well, and I didn't hear what you said.
They read it to me.
They read it to you. Thank you so much.
Yes, Your Honor.
This document indicates that the city will be moving to amend the charge of driving under the influence to negligent driving in the first degree under RCW 46615249. Is that your understanding as well?
Yes, Your Honor.
The elements of that crime are a person is guilty of negligent driving in the first degree if he or she operates a motor vehicle in a manner that is both negligent and endangers or is likely to endanger any person or property, and exhibits the effects of having consumed liquor or cannabis or any drug, or exhibits the effects of having inhaled or ingested any chemical, whether or not a legal substance, for its intoxicating or hallucinatory effects. Do you understand those to be elements of the crime to which you're pleading guilty?
Yes, Your Honor.
You understand that pleading guilty to this crime, which has been amended from a driving under the influence, may cause later convictions for driving under the influence to be treated higher under the mandatory sentencing guidelines of driving under the influence sentences. Do you understand that?
Yes, Your Honor.
You understand this could count as a prior DUI offense, correct?
Yes.
Okay. Paragraph 5 indicates the very important rights you would give up anytime you plead guilty. They include the right to be presumed innocent, the right to testify, the right to appeal, and the right to have others testify on your behalf and without any expense to you, and the right to remain silent. Do you understand? As well as other important rights. Do you understand you have to waive those rights if we're going to proceed with the guilty plea today?
Yes, Your Honor.
Do you have any questions about those rights?
No.
Do you agree to waive those rights so we can proceed?
Yes, Your Honor.
The recommendation of the parties according to this document is that you serve 90 days in custody with 67 days suspended, credit for 23 days served, that you have no criminal law violations, and that you pay $0 in fine. Is that your understanding of the agreed recommendation in this case?
Yes, Your Honor.
You understand I don't have to follow that recommendation. I can sentence you up to 90 days in custody and a $1,000 fine?
Yes, Your Honor.
Paragraph 6G of the statement of defendant on plea of guilty indicates if I am not a citizen of the United States, a plea of guilty to an offense punishable as a crime under state law may be grounds for deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Is it your understand, or do you understand that I'm not asking if you're a citizen, but do you understand that that could be an impact if you are not a citizen of the United States?
Yes, Your Honor.
Do you have any objection to Ms. Mon inputting your initials next to that paragraph to indicate that you understand it?
No, Your Honor.
That's been updated, Your Honor.
Thank you. Ms. Mon, have you confirmed that this conviction has no effect on his, that would disqualify him from driving a commercial vehicle?
Yes, Your Honor, I have. Negligent driving in the first degree does not have any licensing consequences.
All right.
Your Honor, when I was reviewing the plea form, I didn't see any recommendation for alcohol drug treatment, and I wasn't clear from Ms. Amon. I thought that was part of the city's recommendation. Was that not your understanding?
That is not my understanding. My understanding was that once he has taken care of this matter, he also has another matter out of Puyallup to take care of. And my understanding was that it's credit for time served and no new violations.
I'll double check that, Your Honor, while the court continues. I apologize for the interruption. I just want to be sure.
Certainly, thank you.
Ms. Schumacher, it says for standard conditions.
Right, and that's where my confusion is, because standard DUI conditions would include an alcohol assessment, a victim impact panel, et cetera. And I don't see any of that in the plea.
I don't think we have a meeting of the minds. And it is now 2 hours after this calendar began. So I am going to strike this matter. We are going to set it over 2 days. We are not taking any more pleas today. I recommend that in the next 2 days, all the forms be reviewed to make sure that they are filled out completely and that there's a meeting of the minds on all the pleas. So, sir, we're going to continue your matter to Friday. Unfortunately, we don't have an agreement that we can handle this. Is the next available Friday? There's no way to do anything today afternoon. Except just sticking around. What's that? They have a full calendar this afternoon. Do we have any room that we could do tomorrow morning? So, which matters are set for pleas today? There's Jimenez.
Correct.
This matter. Mr. Twy.
Correct, Mr. Twy. Mr. Satterwhite needs to be addressed as not a plea. That's a review and sanctions being requested by the city. Number 10 is an arraignment that needs to occur. Number 14 looks like it was competency. I have not heard from defense what the plan is on number 14. We could start with either the arraignment, number 10.
Here's what I'm gonna do.
Ms. Job is not, Ms. Job is.
Here's what I'm gonna do. Number 4, Christopher DeFalco. What is your intention with that one, Ms. Mon?
That was rescheduled, Your Honor. That's a Resnick matter,
Not on my not on my calendar.
not on the calendar. Strike it. Thank you.
Okay. Mr. Jimenez, we're gonna set that one over. Rochelle Job, what's the intention?
Arraignment today. The city is ready.
She is a refusal.
All right, we can sit over to Friday.
Tomorrow, hold on just a moment, tomorrow morning, or
Oh,
we'll prepare an order for that one and set it over to tomorrow morning, because this is the second refusal in that.
okay. Thank you.
Rachel Thompson,
She is also a refusal. I've not been able to speak with her.
okay, set that one over to when? Friday, okay. Okay, so, Mr. Jimenez, unfortunately, we're gonna set that one over to Friday. Please prepare the paperwork, Ms. Bond. The Rochelle Job, that matter, we're going to set over to, tomorrow morning. And I will ask Wendy to please, get me an order prepped, and I will deal with that issue. The Satterthwaite, that one's a plea?
Satterwhite is a review and city seeking sanctions, or at least we need to discuss it on the record.
Set over to Friday. The Tawai, Mr. Tawai, I'm sorry. It doesn't sound like there's actually an agreement between the city and the defense, so I can't proceed in this case yet.
Your Honor.
So I'm gonna set it over to Friday. Yes, Ms.
Your
Vaughn?
Honor, is it okay if we set Mr. Twy for tomorrow?
No, Friday. So it sounds like, yes, Mr. Twy?
I've been asking to take treatment when I get out. I've been trying to take it. I have my family out there going to Crossroad doing some
Good.
treatment. That's why I was like, well, if today will be the day, but I guess not.
Yeah, that's good. I'm glad to hear that. And I think since we're here, you will get, I just don't know what they want to do is the problem. I don't know what the parties want to do on that one.
Mr. Tawai, if the defense is going to agree that I'll get an alcohol assessment and standard DUI conditions, which is customary in every amendment from a DUI to a negligent driving, standard conditions means standard DUI conditions. If the defense is going to agree to that and add it to the plea, I have no problem proceeding today.
And
Okay,
we have-
so here's what we're gonna do. Here's what we're gonna do. We're gonna take the Jimenez plea. We're gonna take the Tawai plea. If you two can get, if not, sorry.
No, that's
That was
fine.
disrespectful and I apologize to you both. If the parties can get to a place where they agree. I'm gonna take another 5-minute break,
Thank you very much for your patience, Your Honor.
certainly. Apart from the Tawai matter and the Jimenez matter, all the other matters, I don't need to see the defendants. They can go back because the parties are gonna prepare motions to continue and we're gonna set them over. And then if you can prepare for me that order on the, on that other matter, Ms. Job, then we should be ready to go. I'll return in 5 minutes. We're at recess.
Any solution?
Oh, he is done.
Yeah, about 20 people out here.
Amon, can you hear me?
Yes, I can.
Okay, so on Jimenez, did you trash the plea and
Yes, we had, Wendy actually trashed it and then she was able to upload something that populated correctly. And so I
Okay.
filled it out if you want to review that one, and then I'll add the conditions to
all right,
this
it's
one.
not showing up. Let me refresh. Jimenez, I'm only seeing a motion to continue. You're in Jimenez?
It's showing as of 12:34, there is a guilty plea uploaded as well.
All right, I'm gonna log out and log back in because it's definitely not showing up for me.
Yeah, my courts is not working right now.
Federal, Ms. Qualley, Jimenez. No, I only have a motion to continue. You seriously have something else? On Jimenez?
I did, yeah. Let's see. Is the court clerk still there?
No. So do you see it or not?
Not anymore. It was uploaded.
Yeah,
I
okay.
did
So
redo
we need
it.
to put one in. And then the other plea is to why?
Can you add the standard conditions to Tawai and I'll get the
Yes.
other one reloaded?
Okay, guilty plea, yes, I will add the alcohol conditions. Okay, Jimenez, you can tell us what the plan is first, but
We have 97 individuals scheduled for court this afternoon. They need to come into the courtroom.
yeah,
Get rolling on that. We're
Yeah.
gonna reset everybody over to tomorrow.
okay,
So that'll be tomorrow's in custody calendar.
okay, perfect.
And then what we're gonna do, because Pro Tem Cummings has to leave.
Yep.
We're gonna prepare any orders, motions to continue. Go ahead and sign off on those, and then we'll have the judge sign them when she gets done with court this afternoon.
Okay. Understood.
Oh my goodness. I warned you guys that it got worse and I delivered. I have never seen such grossly negligent incompetence. I have no other way to put it. One defendant was supposed to be released today with his plea. But because the paperwork had the wrong charges listed, and she's just like, oh, well, the computer put that in there. We can just do it anyways. No. Oh my goodness. Yeah, that doesn't even cover it. FUBAR. That was what that docket was. Yeah. Wow. I know. And this might be an off day. Like I don't like, being the type of person of saying, this person is terrible. They shouldn't have a job, blah, blah, blah. Because who knows? Maybe this was a once-time thing, But I just can't believe with how messed up it was, with how much stuff was just, she didn't know where it was, or it was ignored, or not filled in, or filled in wrong, or I just don't see this being the first time stuff like this has happened with her. I don't know though. Yeah, it was such a mess and just wrong. Oh my gosh. But yeah, I had to run that one. I just couldn't wait. That is Billy O.T. About this time of night, he starts yowling like that to get into my daughter's room because he wants cuddles from her. And her door's closed because, she's trying to do homework and he likes to lay across her laptop, or he gets kind of feisty and, he wants to play and she can't play. So then that turns into, yeah. No, I know. Yeah, 100%. Oh. I do still like him. I like Pro Tem Cummings. I think he was very fair, and I think he gave a lot of patience to her. I really think he tried keeping his cool. And in fact, that when he said, if the two of you, and he's like, wait, nope, that was disrespectful. I'm sorry. Like, he brought himself back, you know? He was really trying to keep his cool. Yeah, he sure is. Yeah. And like that eye twitch that he's got, and I'm sure that's some kind of like tick or something, like medically, maybe like from, I don't know, maybe a stroke or something. But it got, the more upset that he got, the more difficult it was for him to control that. Or it seemed like it got worse. Maybe it just, that's how it is naturally, and it was an optical illusion, but it really seemed like like the more upset he got, the more his eye twitched. Yeah, Billy O.T. after the Wellerman. Yep, there once was a ship that put to sea. The name of the ship was Billy O.T., which actually is a bucket of tea, because a Billy is a bucket. Oh, it's actually my favorite sea shanty. I love it. So when Kendra got Earl Grey, I wanted Earl Grey to be named Billy O.T. And Kendra's like, I don't want to name him that. That's your thing, not my thing. And this is my cat. And even when I jokingly said, oh, I'll just call him Billy O.T. And she got so mad at me. Like, she thought I would seriously do that. And she's like, that's so disrespectful. Just so mad at me. But it wasn't even, golly, like a week. And then that skinny little kitten, that nothing on him, eating the bird's bread that I threw out, just showed up in my yard, needing love. It took 2 months for him to trust me enough. But yeah, then I got my Billy O.T. and it fits him perfectly. He is a Billy O.T. And Earl Grey, it fits him as well. So yeah, it worked out. I've got more. Let's see here. Let me see how long. No. Earl Grey looks like the name fits him. It does. It fits him. Kendra did well. We struggled because Kendra likes naming her cats after food items. Or I don't know. She's got some process that she uses. She wanted to name him after a food item, but she couldn't think of a food item that was great. And I was like, tofu. And yes, baby boy, where are you? Hi. Yeah, I'm here. So I suggested she name him Tofu, and that almost became Earl Grey's name, was Tofu, until I said, we can call him Topher. You know, like tofu and fur baby was my thought. And she's like, oh, no. There's a character in videos named Topher that I don't like. So that squashed that name. And then it just ended up being Earl Grey. Yes, absolutely. Ooh, he looking for someone. Check your back seat before you get in, if you're not already in your car. That's probably looking for someone. And if they're trying to hide, questioned that. That's hilarious. That is so funny. I know I'm safe from that, though. Oh, and I'm not the type to just pick up my roommate's random pants off the floor and wear them without checking pockets. So I'm good there, too. Yeah, she's hilarious. I love her. Oh my goodness. Yeah, I've got 2 hearings from Judge Ricky. They're nothing like super funny or anything, but you know, I like following cases, and this was, I think her name was Tammy Swanky or Swink or something like that. We'll find out very soon. But it's 2 of her hearings.
This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Tammy Jana Swink. Case number 2021 CR 169. Ms. Swink appears from a Zoom location at the Greenwood County Courthouse. Joseph Favre appears as defense counsel. Jill Gillette appears as Greenwood County attorney. This matter comes before the court at this time for further hearing in regards to a warrant to show cause alleging probation violations, failing to report as directed, and failing to attend her Senate Bill 123 treatment as directed. Court does note that this is not the first probation review in this particular case. One announcement is made at this time, Mr. Favre.
Judge, unfortunately, I've heard it all from Miss Swink. I got an email from her
Okay,
mom.
you're breaking up, Joe.
I'm not able to. Sorry, Judge. Can you hear me okay now?
Okay, better now.
Do I need to move? Okay. I've not heard it all from Miss Swink. I got an email from her mother. So I hate to ask this because I know I was running late, but I need like 2 minutes to talk to her.
Very well. Let's pause these proceedings. And let's put defense counsel and the defendant in the breakout room.
Thank you.
So Senate Bill 123 in Kansas, it is under community corrections. Under community corrections supervision, it provides certified substance abuse treatment for offenders convicted of drug possession who are nonviolent adult offenders with no prior convictions of trafficking or manufacturing or possession with intent to sell. So basically, if they had it for personal use, then they don't have prior convictions, they can qualify for Senate Bill 123. And then that, you know, it allows them to get the treatment and helps with their conviction and everything like that. So she was supposed to do the treatment and the programs and the courses and everything like that, and didn't.
Court at this time will proceed further in State versus Swink following a brief recess. Pertinent parties appearing as before. One announcement is made at this time.
So, Judge, I assume we're proceeding off of the amended motion to revoke that was filed by Ms. Gillette June of last year, as well as maybe the addendum, which I didn't see a new motion, but I saw Mr. Ketley filed a new request for revocation in February of this year. Is that what we're proceeding off of?
That's what I have.
I have a warrant to show cause that was filed in January based on a request by Mr. Ketley that he swore to on January 2nd.
Okay.
Alleging failing to report, failing to attend her treatment as directed.
This is what I have as the historical issues in the case. She was sentenced to 2022. There was a revocation journal entry 12/1 of 22 dealing with revocation. There was a sanction done for issues on 4/16/23. There's a motion filed regarding the allegations Mr. Ketley filed in 23 in June, that I filed an amended motion to revoke because there had been lots of issues happening since 12/1 of 23. And then for some reason, the warrant had not been either entered in correctly or something. And so a new warrant was issued in February or January or February. And then that, there had been a warrant withdrawn in August of 23 after the motion. I don't know why. And then the new warrant had issued in January 5th. Nothing has been done since the sanction on 4/16. So there was the amended motion to revoke issues and then the new warrant to show cause. So she has had a prior revocation and a prior sanction. And then we have the new issues.
Okay.
And there
So I
was,
guess my question is what the court has, go ahead. Sorry, Joe.
it's all right. My amended motion to revoke was filed in June and it's never been heard. And then we have a reissued warrant as she was arrested in Sumner County on that warrant.
So the packet that was sent to me from the CAs has with it the warrant to show cause that was sent February 13th, 2024. That was filed in the court. On February 13th. And that's the one that I think the court mentioned that it was failing to report on November 30th and failing to attend Senate bill treatment as directed. So I just want to make sure which one we're proceeding on. If it's just that one, great. If it's that one plus what Ms. Gillette's mentioning, that's fine, I guess. I just need to know what we're admitting to.
All right, it would be the court's position that we're proceeding under Mr. Ketley's affidavit and warrant to show cause issued in January. Any motion filed months before that in the view of the court is stale. At this point, we're going to proceed solely on Mr. Ketley's January allegations.
Okay. I've spoken to Ms. Swink about that, Judge, and Ms. Swink will stipulate to those violations.
All right. All right, Ms. Swink, you've heard your attorney's statement. It's his understanding that you're going to stipulate or agree that you committed the violations of alleged Mr. Ketley's recent warrant to show cause, recent saying that it was in January of this year. Those allegations were, again, failing to report as you were supposed to and failing to attend your Senate Bill 123 treatment as directed. You do have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You could challenge the state's evidence with the assistance of your lawyer, confront the state's witnesses unless good cause was shown. And I need to point out that among other lesser remedies, the court could just consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things, Ms. Swink?
Yes, sir.
Do you waive a hearing in this case and stipulate and agree that you committed these failing to report and failing to attend your Senate Bill 123 treatment?
Yes, I did fail to report then.
Okay, I'm sorry, I didn't hear that last.
Yes, I did fail to report then at that time.
Okay, you did fail to report.
Yes, sir, I did fail to report during that time. I've been keeping in contact as much as possible since.
Okay. So you acknowledge that you failed to report to your probation officer, right?
Yes, sir.
And you failed to attend your Senate Bill 123 treatment as directed?
Well, I completed it all except for a little bit of it, yeah, and I've been trying to find something that matches my insurance. Because it came off my Senate bill. They said my Senate bill was closed.
Okay, well, Ms. Swink, this is an important issue. I'm not sure if you're admitting that violation or not. Either you completed Senate Bill 123 treatment or you didn't.
I didn't complete it all the way. I got my inpatient my completions from there.
Okay, we'll talk more about that later. All right.
Okay.
There is, the court will accept the waiver of hearing and acknowledgement that she failed to report to her officer as directed and failed to actually complete her Senate Bill 123 treatment program. These are substantial material violations of the terms and conditions of Ms. Swink's Senate Bill 123 oriented probation in the case. I've just got one other issue I want to address. If you'll bear with me a moment, counsel.
What's your paper there? You got it.
The issue that I'm trying to research here is to whether this request for revocation of probation was still within her probation period. I do note the original sentencing date was March 31 of 2022. She was placed on probation for up to 18 months. That would have taken her to December 31 of 2023. Mr. Ketley filed this motion or this warrant to show cause in January of 2024, which appears to be within the 30-day window past expiration period that he is allowed. So not by much, but it does appear to the court that this was a timely request for revocation of probation in the case. If there's any disagreement, I want to hear that now. Mr. Favre?
Judge, just crunching my numbers here, sorry. Sorry, give me a second here. So.
Oh, you're, okay, hang on. Maybe perhaps my math isn't correct here.
There was an extension done, a voluntary extension done in this case on, when was that done?
September 28.
September 28. And that was a 6-month extension, correct?
Okay.
Yes.
Which puts us, I think, March of 24, if my math is right, which means that we're within the time frame there. I think we're fine.
Very well. The extension document is not readily before the court. I do appreciate that clarification. We will proceed further with dispositional proceedings here. And sorry about the delay because of the court's faulty mathematics and reliance, I think, just on the papers before it. All right. Court will take recommendations from each attorney regarding an appropriate disposition. I'll start with Jill Gillette on behalf of the state.
Judge, it's the defendant's responsibility to be contacted their ISO, having to track them or try to come in. Mr. Ketley has done a lot to try to keep Ms. Swink tracked down, give her extra options, and do extra things for her. He even set up worked with her to set up mental health evaluations. She no-showed to those in the history of this case. There's information about those being set up for May 3rd and June 21st to try to help her with her mental health, because her mental health is an issue as well. She no-showed to those. She's failed to report to him as directed throughout the entirety of her supervision. The best she did was when she was in the sober living house. And when she was not to move out of Sedgwick County when she was in that sober living house. She ended up doing that, and she left without permission. She's moved around, not kept him informed about employment, housing, where she's at, what she's doing. She absconded and disappeared for a significant time period in there. His warrant to show cause said that she disappeared after November 30th. This warrant was issued January 5th. That's all of December. He didn't know where she was to the point he issued the warrant, asked for it. She had needed to complete successfully Senate Bill 123. She'd been in and out of different places that he'd arranged for her to go. She did not fully complete her treatment program. She's now out of Senate Bill 123 treatment time. She had a prior revocation on December 1st of 22. She had a sanction in April for 2 days because she did not go to treatment. There's choices and consequences for everyone. I make choices. I have to live with my consequences. Everyone on the screen makes choices and has to live with those consequences. Ms. Swink continually chooses to stop talking to her ISO throughout the entirety of her case. She'll get back on for a little bit because she's in trouble, and then she'll disappear again. We understand that her mental health was an issue, so options were given to her to treat her mental health, and she didn't treat her underlying mental health. She chose not to. This entire supervision, she goes and does what she wants and doesn't think that she has to have consequences for it. Now that she's had a sanction and a first probation revocation, we're up here on a third time of issues. This is her second probation revocation. She just frankly doesn't want to do her treatment and stay in communication with her ISO, which are two of the things that are necessary for her supervision. I don't think I have any choice because she's made the decision she's made, but to ask for an outright revocation and for her to serve underlying time. I don't think I have any other choice at this point.
Very well, Ms. Gillette. I'm going to
That was kind of brutal.
address Mr. Ketley, the supervising officer, next. I want to give Mr. Favre and his client an opportunity to respond, whatever he may relate to the court. You've been engaged in supervision with this individual for an extended period. Do you have any independent recommendations or remarks, Mr. Ketley?
No, I don't, Your Honor.
All right, Mr. Favre.
Judge, I think Ms. Gillette has highlighted a lot of the shortcomings Ms. Swink has had. I think Ms. Swink, just in perfect candor, has been a little bit, she's a little bit frustrating, Mr. Ketley kind of supervised. I'm not trying to say that to speak ill, but just to recognize the reality of it, of what it is, which is it seems to be one step forward, two steps back, two steps forward, one step back. On one hand, she's completed inpatient. On the other hand, she's for sober living house. She's paid almost all of her case off. She owes $98 owes, which most people don't make payments. Has now set up her insurance and her have to get her own treatment. Her request today is that the court give her, allow her to finish up treatment on her own dime because she's burnt her Senate bill. She knows she's burnt her Senate bill. And she's finally in a position where she can successfully complete treatment. And just in all candor, I understand why it's a recommendation, but that's the request we're going to make because people take a lot longer to get stable. She seems to be at the point now where she's getting more stable. She has family support, which you can see behind her. We're going to ask for one more chance at probation, even though this is a long case. In the alternative, we ask the court to consider acknowledging some of the positive things that she has done in her case regarding completing inpatient, and consider modifying her sentence if the court is inclined to take the state's recommendation. But that'd be our request today.
Very well, Mr. Favre. At this time, the court will address the defendant, Tammy J. Swink, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she personally would like to present to the court. Ms. Swink?
Yes, sir. I would like to present that in November of 2023, I was working at Smart Style and I was reporting with Ed. It was in mid-December is when I stopped reporting with Ed for those few days. And I did appreciate him reaching out. I was working at Smart Style in Wichita, Kansas and West Kellogg. And I did have jobs. I still have had jobs. I just recently was hospitalized, so therefore I've been without work here just in this little bit. But I'm ready to get back to work. As soon as this heals up, I got bit by a brown recluse and had blood poisoning, was in the hospitalized for 5 days by ambulance. So also I've been reporting as much as possible. Even when I was in the hospital, I was letting Ed know, having my mom call. And it's not just when I'm getting in trouble. I feel like Ed really did help me at that point. When he did put the warrant out, it really helped me get back away from a living situation. And I also just been trying, like Joe said, on my own dime, getting it. And now I got all my insurance lined out and my family support, because they really do see that I am not just out playing a game or, being irresponsible. I've been trying to get away from situations to where I can get my things that I need done completed. And that's all I have to say, Judge. And thank you for your time.
See if you can move shit if you're wrong.
Who's talking?
That's Ms. Swink's mother, Your Honor.
Okay. Ms. Swink, I agree to a very large extent to what Ms. Gillette is saying to the court. When you don't complete your probation conditions, there should be penalties, there should be implications, there should be consequences. You had definite probation requirements to meet, the most fundamental of which is report to your officer as that officer directs. You haven't done that. Further, the entire focal point of your probation in the first place was Senate Bill 123 treatment, and not just one component of it, but a long-term painstaking program to support your rehabilitation. That's what Senate Bill 123 is all about. In fact, the state of Kansas is even willing to invest essentially taxpayer resources to assist you in that regard so that you don't have to go to prison, rather be rehabilitated and become a productive member of society. I would have thought you would have understood that by now, that every single component of your Senate Bill 123 treatment program is critical. Ms. Gillette recommends an outright revocation of your probation, which means you go to a women's penitentiary, a women's prison. Mr. Favre, as I understand it, recommends just putting you back on probation and letting you do your treatment. The court's ultimate solution here will be in between. Ms. Swink, there needs to be a serious penalty for noncompliance. This case should have been successfully completed by now. Mr. Ketley's made yeoman efforts to try to make that happen, and you haven't cooperated fully. So the court is going to order, as a sanction for noncompliance, 60 days in the Greenwood County Jail, effective immediately. The alternative would be that you go to prison for much, much longer, Ms. Swink. And then I will reinstate your probation one last time. You're going to need to contact Mr. Ketley with Community Corrections immediately upon your release from the jail, which means either that day you get out or the very next business day that their office is open after you get out. As I often point out to people, it's not his job to track you down again. It is your job to contact him when you get out and that you're free to come report in person.
Yes.
And how would you recommend she do that? What means of communication, Mr. Ketley?
She can call me. She has my phone number. She can call me, Your Honor.
Okay. He's directing a telephone call, and that's what I'll require you to do.
Yes, sir.
I frankly, at this point, and it's difficult to know, especially since it apparently took 4 months after this warrant to get you to court, which the court doesn't find particularly acceptable. Nevertheless, I think you need a new assessment from an alcohol and drug treatment provider as to what your current needs are.
Yes.
You say you've completed an inpatient component, which is generally detoxification. That's the purpose of inpatient. It's not really meant to be a long-term solution. So to what extent you need to be attending treatment meetings at this point or aftercare, whatever it's called, I think that needs to be reassessed. And if you're part of an existing program, I'm sure one of their program directors can write an assessment for Mr. Ketley so that he knows exactly what your requirements are at this stage. And I want you to successfully complete those.
Yes, sir.
Ms. Swink, so that you don't have to go to a women's prison.
Yes, sir.
No further costs will be assessed at this point. I don't see that you have the financial resources, wherewithal to be able to pay them. Anything previously assessed, you still owe. I'm also going to extend probation in this case formally to December 31 of 2024 for the rest of this year. You have plenty of time then, even after the 60 days, to get your requirements met, Ms. Swink.
Yes, sir.
And hopefully it will not be necessary to extend your probation any further. Tammy, I'll be honest with you, this is your last chance. I hope you understand that. Either successfully complete the program and probation or do the time. Those are the only options. Is there a law enforcement officer in that room?
No, sir. I think he's by the waiting thing. You want me to go get them or?
Okay, you need to report immediately to the Greenwood County Jail facility to begin your 60-day sanction period.
Absolutely. Will do.
All right. Ms. Gillette, is there anything further we need to address on Tammy Swing?
I can't think of anything. I was just texting law enforcement.
Okay, thank you.
Yeah, there's an officer here now.
All right.
I'm here, Your Honor.
I don't think Jill Gillette had a whole lot of faith in Ms. Swink just going and reporting herself. She wanted to make sure that the jail staff got there now to remand her.
Okay, thank you very much. She's in custody for the next 60 days.
Thank you, Your Honor.
All right. Mr. Fabre, anything further?
No, Judge, thank you.
Very well. Then the Tammy Swink matter will currently be in recess at this time. We'll move on to another case.
I really quickly, I need to stop and say thank you to Shane. Thank you so much for the Cash App Super Chat. I can't tell you how much I appreciate that. It goes a long way, especially when YouTube's not taking their cut. There is a link tree that Emily and Philip made that has all of the links of how you can support the channel and me and the pets. So it's got all of the links in there for PayPal, Venmo, Cash App, Amazon, all of that stuff is in there. So I am so grateful. Thank you so much, Shane. You're awesome.
Now, Mandy, you wanted Ms. Williams to get on this hearing, correct?
Yes. Did you ever get a hold of her?
I did. I sent her the Zoom link. So hopefully she'll be getting on here because I sent it to her earlier. She has it. She's had it for a while now.
Okay, the Zoom link on Williams, I think actually had a start time of 11:30, but she's passed that now by 19 minutes.
She's way past it.
But you know, if there's any contact you can make.
Are they not supposed to appear at the courthouse for a show cause?
Did she get told to do that? Because there was some confusion on what she was told.
Well, they should be told that in every single case.
I'm not sure what she was told. Let me see here. Let me make sure I gave her the right Zoom because there was a Zoom for her case separately.
Okay.
Let's see. Nope. No, I did give her the correct Zoom information.
You have a phone number on her, Joe?
I do. She's been texting me all morning. If I could try to.
Okay. Go ahead and do that. Let's keep the proceeding open for now. He should be right back. Joe, come back on as soon as you can.
Donna, turn your camera on and mute yourself.
Hi. Here I am.
Donna Williams?
Yeah.
You are very late. Let's go ahead and begin this case. It is State of Kansas versus Donna Anita Williams. It's Greenwood County case number 2022 CR 92. Joseph Fabre appears as defense counsel. Jill Gillette is prosecuting attorney. Donna Williams appears on her own Zoom. Ms. Williams, if you can clarify your video where we can see your full face. This matter comes before the court at this time for review of the defendant's sentence on a warrant to show cause alleging probation violation. The request for revocation of probation and subsequent warrant includes failure to obey the law, failure to avoid alcoholic beverages or illegal drugs, failure to pay, fail to not associate with persons on court-ordered supervision or convicted felons, or illegal drug users or people who make alcohol or illegal drugs available. All alleged by Carrie Seeley, the court services officer in the case, pursuant to a warrant to show cause apparently sworn to on or about February 20th, 2024. Favre, what are your client's intentions regarding the allegations before this court?
So Judge, proceeding off Ms. Gillette's motion, a revocation and the warrant
Okay,
show
you're
cause
breaking
issued
up
by Ms.
again,
Sealy,
Joe.
she'll stipulate. Sorry, Judge, if we're proceeding off of Ms. Sealy's warrant to show cause, I think she would stipulate to what has been listed by the court and waive a right to an evidentiary hearing on those matters.
Ms. Williams?
Yes.
Yeah, you show that you're muted. Okay, all right.
I'm not muted.
You do have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You could challenge the state's evidence with the assistance of your lawyer, confront their witnesses unless good cause was shown, present your own evidence, and I need to point out to you that among other lesser remedies, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up in jail. Do you understand this?
Yeah.
I'm sorry?
Yes.
Okay.
Yes.
And do you now waive a formal hearing in this case and stipulate and agree that you committed the
Yes.
violations as the court read off earlier?
Yeah.
All right. The court finds that the defendant has knowingly waived her right to a hearing and stipulates and agrees to the violations as earlier read by the court. Court finds that these are significant and substantial violations of the terms and conditions of Donna Williams' probation in this case. Court will turn to disposition at this point. Ms. Gillette, your recommendations?
Your Honor, Ms. Williams, when she's sober, she does great. When she falls off, she doesn't. So she has a new case that she's picked up here. We currently have a no contact order with her co-defendant, which is another lady around town. She's, I believe, moved to a different area and she's been back in treatment. I think Ms. Williams needs to have more intensive supervision than perhaps court services has. Because when she has supervision, she usually does well. But she goes off the rails, and that's when she has lots of issues using. This is, I believe, her first time up in this case. I would ask for a sanction on Ms. Williams and for her to be transferred over to community corrections. It's anticipated that her new case will place her on community corrections with an intensive supervision officer. At its conclusion, I believe that a sanction would be appropriate for Ms. Williams.
Ms. Gillette, has that case been disposed of? Is it awaiting sentencing, or what's the status?
We're at pre-arraignment, Your Honor, still in that case.
All right, thank you. Go ahead, Ms. Gillette.
It's anticipated we're in plea negotiations in that case, Your Honor. There's been a plea offer to Ms. Williams. Would like to see her transfer over with a sanction to community corrections, and then have her place, which I don't know if she'll need an extension of time in this case. She was sentenced, I was looking at her sentencing date. Her plea and sentencing was June 8th of 2023. It was for a term of 12 months. I would like to see the extension of her probation in this case because it would be up in June next month, to have her get back into treatment. I believe she's already re-entered treatment, but to extend her for at least another 6-month time period and have her go on over to intensive supervision.
Very well. Ms. Seeley, I want to have you address the court next. You've supervised this individual. Do you have any independent recommendations?
Not at this time, Your Honor.
Thank you.
Thank you.
Fabre, you may, at this time, make your recommendations regarding an appropriate disposition.
Judge, Ms. Gillette's correct in the posture of where this case is in regards to the fact this is her first time up. She is also correct regarding the posture of her existing case that we are currently working on a plea on that's not been done, but it is going to end up likely with it being a case where she's placed on corrections. I think the overall statement of Ms. Gillette regarding Ms. Williams on drugs versus off drugs is accurate. She is currently set with a bed date of June 6th. She's also working. So we think the overall recommendation of a sanction and then placing her on corrections is very appropriate given all those factors.
And your phase in the representation of this client?
I don't have them calculated just yet, Your Honor. I would guess not much, probably somewhere in the neighborhood of 250, 300, I would guess.
All right. What kind of job does your client have?
I'm not entirely sure. Ms. Williams, where are you working at right now?
It's a place called Superior Building Management, and we go around cleaning different businesses and the floors at nighttime. And then some mornings we go in businesses that are open later and kind of clean.
Okay, your voice is trailing off, Ms. Williams. You're really going to have to speak up.
I'm sorry. I work for Superior Building Management. We clean floors at different businesses.
Okay, how much do you make doing that?
12.
$12 an hour?
Yeah.
Did she answer?
Yes.
Yeah, she said $12 an hour, Your Honor.
Okay. All right, is that full-time then, Ms. Williams?
Yes.
Okay. This time, the court will address the defendant, Donna Anita Williams, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to represent to the court.
I am going to have a bed date of June 6th, but I'm trying to go to another treatment that might be able to get me in sooner. But I do have that bed day and an outpatient, but I am trying to go to inpatient a lot sooner somewhere else.
Okay. Ms. Williams, were you not told you had to appear at the Greenwood County Courthouse for today's proceedings?
No.
You weren't told that when you made your first appearance?
No.
Normally Judge Webster does, Your Honor, and I write it down when she says it. For some reason, I don't have it in here, and I don't know if we were in a hurry or if it just got missed in this case, but I usually write it down when it does get in
Very
there.
well, the court will announce its disposition at this time. For the substantial material violations of the terms and conditions of probation, the court will impose a 3-day dip sanction on Ms. Williams to effective immediately. Ms. Williams, I'm going to have you report to the Greenwood County Jail by no later than 2:00 p.m. today. Ms. Williams, I want to make sure that I impress upon you what the stakes are here. If you don't voluntarily appear at that jail by 2:00 p.m. today, the Greenwood County Jail in Eureka, Kansas, you'll be back before this court to review your sentence again, and it would be the intention of this court to outright revoke your probation and have you serve it all. If I can't keep you on probation anymore, after you serve this jail time, and I'm presupposing Ms. Williams will report and serve her 3 days, then she needs to report to her court services officer as directed, because the court is not transferring probation in this case. Ms. Seeley is going to keep this case under her supervision. But Ms. Seeley, I'll make the order now that if she is placed on community correction supervision in a felony case, you should immediately transfer the case to that community corrections department on my authority, because I don't want her on dual supervision. But I want you to keep this case until such time, and I'm not going to presuppose she's ever going to get convicted in the other case. But if she is, she's placed on community corrections, then the transfer is to take place. You need any clarification from the court on that, Ms. Seeley?
No, Your Honor. Thank you.
I'm extending her probation in this case for 1 full calendar year. So whatever her original expiration date is extended for 1 full year beyond. And I'll go ahead and announce it for the record. The sentence was pronounced June 8 of 2023. She would have expired otherwise on June 8 of 2024. She's now on probation in Greenwood County case number 22 CR 92 until June the 8th of 2025, unless obviously terminated earlier or otherwise lawfully extended. Regarding additional fees in this case, the court does believe that there should be some financial penalty for having to reappoint Mr. Fabre. I'm going to essentially impose half of what Mr. Fabre quoted to the court as additional fees owed in the case. I'm going to assess an additional $125 of legal fees onto Donna Anita Williams in this matter. Waive the remainder. All right, I think I've covered all the necessary aspects of a disposition. Mr. Fabre, are you aware of anything else we need to address here?
No, Your Honor.
Ms. Seeley, are you aware of anything that still needs to be addressed or clarified?
No, Your Honor. Thank you.
Ms. Gillette, anything further?
No, Your Honor, thank you.
And last and certainly not least, Donna Williams, if you come back on again, do you have any questions about what the court has done today?
No.
Okay, you've got about an hour and 49 minutes to appear at the Greenwood County Jail in Eureka to serve your sanction time. If there's nothing further, then the Donna Williams matter will currently be in recess, and this meeting may be ended for all at this time.
Yeah, he was done with the shenanigans for sure. Chadasket, honey, I am so sorry for your niece and what she's going through. I know we're all gonna be keeping her in our thoughts and prayers, sweetie. Yeah. This is one of those little balls with treat on it for cats. It was full about an hour and a half ago, 2 hours ago. No, 2.5 hours. I've been live for 2 hours. So about 2.5 hours ago, it was full. It had this lid on it. I took this lid off of it so that Billy could have some of it. No cat has been here since. And yet, it's empty. Where did it go? Where did it go? Where did the fish ball go? Yeah, that's what I thought. That's what I thought. Was it good? Did you like it? You liked it, huh? Well, you're not getting another one. I'll put it farther up on the desk. Of course, I know you get up and eat the cat food no matter where I put it on the desk. Because you can stand up and pretty much reach anywhere. And you'll pull the plate closer to you. Quit looking at it. No. She got a hold of it. And it is gone now. See, this is how big the ball was. Here we go. Here we go. I got like 3 left from Chex and Cherries. Getting the lid off the first time is always fun. Pre-Ava, post-Ava. You see how that goes. Yeah. Hi. No, you don't get the cat ball. That's the cat treat. The cat treat. She has pulled these off of places where I've stuck them. And I've found this disc chewed to bits. The only reason this one was not chewed to bits is because I stuck it to my desk. I tell you, she's something else, y'all. She's something else. I put one in the windowsill on the side wall of the window. She got it. Because I thought the cats could lick on it while they were bird watching in the yard. Ava got it. The one on my desk didn't work. The one on the wall doesn't work. She'll push the cat loft out of the way to get to it. It's edible and it smells fishy. It's got like fish and veggies and, you know, omega proteins. And get off my laptop cord. Wow, come on, out of there. You just made my camera move. Oh, yeah. Ava's lawyer is here, y'all. The defense attorney, Becky D. Well, it was because you were watching it on the road, and so your network was slowing you down. I know when I leave my Wi-Fi, if I'm running a video and I leave my house, it'll buffer, and like the buffering doesn't last very long, but it puts me behind a little ways. But then I notice as I'm going, because I put it on the Bluetooth. I've got a Bluetooth FM adapter so that I can have Bluetooth in the car and listen to it over the radio. And excuse me. So I'll listen to it on the radio. I don't watch the video, but I have the audio going. And that way I can, you know, still find decent dockets whether I'm home or not. But I notice like it'll not really pause, but it'll like, you know, break and buffer, but it's momentary, so you don't notice it, but it adds up. Oh my gosh. My cat Crow loved Carmex. If I had Carmex on, he was all kinds of up in my business. Yep. Oh, see? It's okay. You can't be nearly as much of a mess as Attorney Mon. That's going to be the new standard of mess. Hi, baby. You've got bad breath now. Your breath smells like fish. I wonder why. Let's fix it. Let's give you something that tastes delicious and smells great. It smells like cinnamon and pumpkin. Yeah, I don't have one in the hand yet. I just have that because I can't rest it on your big old noggin. Then nobody could see your face. Your pretty, pretty face. Okay, I got your 3 biscuits, as I'm sure Philip Heels would refer to them. Your Blue Buffalo Health Bars, one of your favorite things in the entire world. Yeah. Follow the bag. Are you drooling on my desk for real? You are. She's drooling everywhere, you guys. You're so good. You're being patient tonight, other than you drooled everywhere. Oh. I really don't. I really don't watch other channels, just the dockets for, you know, being able to find quality content for you guys. I know what they smell like. I know that fishy thing didn't smell great, but she sure loved it. These health bars, they smell so good. Ava will only eat the carrots if they're frozen, the little square ones. If they're round, she won't touch them. But she will eat the little frozen ones that come in the bag of mixed carrots and peas. Right on the side of the lip. Not in the mouth, though, thankfully. Hi. Hey, wait. Are you forgetting your manners? Wait. Are you forgetting your manners? I'm saying please, Mama. I'm saying please. This is please. Hey, speak. That was close. Speak. Honey, is that a trick question? That's a trick question, right? You know he's kind of why I'm doing what I'm doing, right? He's the one that I used to send him videos all the time. And then one day he's like, you always have such good stuff. Why don't you just run it? Make some money. I'm like, what? I'm like, I don't want to go live and have people looking at me all day. He's like, no, it's great. You'll love it. Do it. I have a hoodie of his that he gave me that I wear it all the time. Oh, there's something it's a specialty, organically grown here in the United States. You Australians wouldn't get it. Yes, I know, the star of the show. I'm so glad that I trimmed her nails. There's no way I can get my leg up that high to show you, not without severely hurting myself, but she did a number on my leg. Okay, new rule. Must wear pants. Must wear pants before the Ava show. Ava claws hurt. I got little red streaks. I think they'll go away. They're not cut through, but they're streaky, full of Ava claws. Oh my gosh, that's so funny. You sure it wasn't a bunny rabbit? Thank you, Catherine Gaston. Thank you so much. You are such a sweetie. Yep. Go get a drink. Yeah, he's a sweet guy. Yeah, if you go back about 7 months, 8 months, 9 months, in that vicinity, there was like a couple of months where I kept sending him stuff. Yeah. Nope. No, Emily. Ooh, nifty. Hold on, I gotta see this. Hold on. No way. Okay, first off, I gotta hide that. Now I gotta do this. I gotta do this. I gotta do this. Okay, it's a thing. For real? Y'all. They even grow heart ones, dudes. Who thought of this? They're $100 to $200 each. Lasts up to 6 months, harvested unripe for longer shelf life. But it says it's ornamental. Wow. And there's a purple one. There's thumb-sized watermelon. There's all kinds of colors. Wow, y'all. I'm just... Earl's even shocked. That's super pretty. That's real pretty. Wonder how they taste. Oh my gosh, that looks like a kiwi. That looks like a kiwi. That actually looks more like a dragon fruit. The white one looks like a dragon fruit. And then that looks kind of like a kiwi. Oh my, I am astonished. I am befuddled. I am flabbergasted, bamboozled. This is wow. Wow. What? Oh, that's a hoax. Oh, golly, that's pretty. Oh. Wow. Okay. Sorry, I'm back. Uh-oh. I missed this. I'm sorry. I'm sorry. Aw. All right, I'll make sure to go there and check it out and go straight to that timeline to see. Yeah, see how much we learn on here? We learned. I know. Oh my gosh. Wow, I never have. See, and I'll be honest, it's not my favorite fruit. I love watermelon candies, like Jolly Rancher watermelon flavor and stuff like that. But actual real watermelon, like there's only specific, I guess, species of watermelon. I don't know, breeds of watermelon, whatever you call it. There's only like a certain watermelon that I really like, and I don't know what it is. I definitely know it's not what comes from Walmart, but like watermelon that just tastes bland is not my thing. I love it when it's sweet and like summer, you know? Oh, the thumb size ones are cucumber relatives. Google's tricking us. They are. No kidding, right? A cucamelon. What does it taste like? Well, what we saw there were the price of the seeds. Oh, it's not growing that color. That is not cool. That is not cool. I don't know what that is. Would you please stop licking? Please. Please. I hate that sound. I really don't lick me, please. Oh, okay. Thank you. Had no idea what you were talking about. Now it makes sense. Wow. I love you. Everybody loves you. Come on. Everybody loves Ava. Yes. You're the prettiest, smartest, funniest. That one's real. Yes. Look at them. Look at them. Oh, you're going to be shy now? You're going to pretend? You're going to pretend to be shy? Yeah. Everybody loves Ava. Mama's baby. Ruth Ward. Watermelon covered in potatoes? I'm glad I didn't have any weird cravings, but let me guess. Were you pregnant with a boy? Was it a boy? Oh my goodness. Hey, apparently that tahini stuff is really good on fruits. Wow. I didn't have any pregnancy cravings, really. I thought I would, but I didn't. Right. I'm not going to knock you for it. You can't really control that. All right, guys. It's 1 a.m. I'm sorry. I'm getting tired. My neighbor, he's Mexican. He tells me that all the time. He does. Truly. Like, it's hilarious. It's to the point where it's actually hilarious. You know, because he'll be like, you know, something will break or something. He'll have to figure something out, and he'll be like, "It's okay. I'm Mexican. We do everything." Okay. He's so funny. But anyways, he and his cousin are going to start a catering service or a food truck, one of the two. Apparently they have like a lot of the equipment. They're moving it up here for it. And one of the things that they're going to have are these watermelon pops that are literally coated in tahini. And apparently it's like super amazing. So I don't know. I've never tried it. Oh, I love pineapple. Oh, I love pineapple. I like lemons. I will slice a lemon and I will eat a lemon, a raw lemon. Love it. Love lemon. Yes, please. Thank you, Sir Philip from Mallee, Victoria, Australia. Tajin. Just look it up. It's at every grocery store, Walmart, Amazon. You can find it anywhere. There's multiple flavors. It's a seasoning. It comes in either a liquid or a shaker. And I accidentally got a liquid, but he said it was the one that was used on fruits. I gave it to him. He said it was called chamoy. What? Okay. You don't want it to take off the enamel? Maybe it'll lighten them. Okay, can I have my hand back yet? I gotta do my wave. Okay, guys. She's up on the bed now, waiting for Mama to come cuddles. Hey, quit that. All right. I hope you all have a wonderful night. Thank you for coming and hanging out with me. Be safe, be well, sleep sweet, and much love.